getting to what we especially heard from the public school speakers last time. So that's why I make the motion that we recommend report of the substitute that's before us.
Second.
Madam Chair, I did have a question. I heard some of the dialogue. I don't understand how adding the parental piece hurts the bill, though.
So here's how it potentially hurts. So I don't know whether, Senator Bagby, you were here last week, but this arose from a situation in which in Harrisonburg City Public Schools, a student was in a residential placement, was discharged with some very violent tendencies, and they were part of his discharge summary. The school had no information. The police had some indication that this student was very dangerous. The school had to operate essentially in the dark. The student ultimately was withdrawn and went elsewhere, but the school was, to put it mildly, they were alarmed at the risk that they were in because of this undisclosed information about the danger that this student posed after mental health treatment. It was in his discharge summary. So if a parent like the lady in Minnesota who is aware of her child's mental health issues, aware that the child has a gun, aware that there is ammunition, aware that this child is dangerous, but just simply refuses to admit it. It just is convinced that this is just a misunderstanding with respect to my child, and we see that with some regularity. That parent may say, I'm not going to give consent because I don't think that they need to know that. Or in my area, and frankly in a lot of areas, there just are some really poor areas in which folks just don't understand and may not have that line of open communication with the schools, and just may not choose to provide that support. And that child, as a result, may not receive the educational services that are included in that discharge summary, or may not receive the counseling and mental health assistance through the counseling to make sure that he or she or their classmates remain safe.
I have a question for General Counsel. If in fact the child was deemed to be a danger, which is really the main argument that's being presented here, danger to himself or others, does the healthcare provider, in this case, this is a discharge plan from a hospital or a residential facility, so there's a healthcare provider here, does the healthcare provider have a legal obligation to perform the school system anyways, regardless of parental notification?
Madam Chair, I do know that there is one particular provision, it is in the administrative code, that provides that providers, this is particularly in reference to psychotherapy notes, where it exempts them from having to obtain an individual's authorization for any disclosure except when disclosure is made in discharge of the provider's duty in accordance with section 54.1-2400.1 to take precautions to protect third parties from violent behavior or other serious harm. So there are certain requirements that, certain legal obligations or duties that create exemptions to these authorization requirements for the disclosure of information. I'll have to take a moment to see if there's additional ones, but that is the first one that I'm able to find.
There's already a legal obligation if there is deemed to be a danger to have it reported.
That's not quite what I heard counsel say. It sounded like it was an exemption that allowed disclosure. I don't believe that this is a,
Correct, it is an allowance, it's not a requirement, but the provider, if they deem it, again, an imminent danger to yourself or others, could disclose it to the school without parental consent. We are talking about minors here.
but they don't, and they didn't.
Madam Chair.
Senator Ayers.
I guess, Senator Obenshain, what I hear you saying is that there is a concern from your experience about solely depending on a parent to give authorization. Was there even a discussion that has occurred around parental notification of some sort?
What happens in this case and in many cases, my understanding is that child is discharged back home. The child just shows back up at school. And the school, in this instance, had no idea that the child was coming back. This would have required the discharge summary to have been provided. After the child came back to school, there was ultimately some interaction with the family, but at present, child just shows back up.
Madam Chair,
Senator Ayers.
speaking to the bill, I think somebody did make a motion. Senator Obenshain, I feel like I get the intent of what you're trying to do, and I actually think it's really important. Like when I think about my own kids and when I think about the school environment, I think we can all agree that we don't want a young person that is perhaps not fully in a position to be back in a school environment to put anyone else at risk. But in that same breath, I would be alarmed to learn that my child's information, particularly sensitive health information that could change whether or not they can remain in a school environment, to be shared without me being made aware. And so I hear what you're saying about this terrible occurrence, but I have to agree with the chair that we have to ensure that parents are part of this conversation and that they are at the table when this is occurring.
So could you live with a notification a contemporaneous notification to the parent that the information is going to be provided to the school counselor? This child's coming back to school.
At this point, we can't.
The child is going to need
I think we
those
need something
educational
that involves the
services.
parent.
I would ask that notification be given to the parent. You have narrowed the information sufficiently,
I think that would be great, and I have no objection to
but
that.
there's no guarantee that, we may, as we continue to talk about this, things may happen on the floor. I just want you to know that.
We can't force parents to be involved, and I understand
No, but
that.
they need to be aware that this information is being shared
100%
with the
okay
school.
100%.
And I guess I'm thinking, if we're not proactively asking for their permission, could they opt out of that information being shared? And again, I would ask counsel that.
Just think about Ms. Crumley, whether she would have opted out.
And I'm thinking about a number of situations where this is very sensitive information about the child, and we're sharing it with an institution that doesn't have the tightest security. Okay, I'll let counsel answer that question. Yeah, could a parent opt out of having the information shared with the school? It's the reverse of proactive consent.
Madam Chair, I don't see any reason why there couldn't be an amendment added to this to allow the parent to opt out of having the information shared, except in the event that it does implicate any specific legal duty to take necessary precautions to prevent any reasonably certain instance of violent behavior or other serious harm, which also, to clarify, that section I referenced earlier with that duty, it is a duty, but it also only applies when the client has orally, in writing, or otherwise communicated a specific and immediate threat to cause serious bodily injury or death. So it is a little bit more narrowly tailored than what the provision in the regulation made it sound like. But in more limited circumstances where it isn't that specific and immediate expressly communicated threat, I think there could be an opt-out, a parental opt-out, very carefully drafted into this substitute.
Okay, so I'm gonna ask the patron if you could agree in concept to an amendment that notifies the parents and within a certain amount of time, the parents would have to opt out or all the information shared with the school.
I'm at the pleasure of the committee.
Okay, we're gonna consider that a friendly amendment. I have a motion on the table. Withdraw your motion. To withdraw the second. Okay, motion's been withdrawn. Madam Chair, I move that amendment be to add notification with opt-out option. Okay. And where's the second? Okay. All those in favor of that amendment signify by saying aye. Aye. Okay, so now the substitute is before us as amended. Would you like to make a motion, Senator Suederline?
Sure, I would move that the substitute as amended be recommended for report by the full committee.
Second.
So we'll see this in its latest form when it gets reported. Now, I don't have a fiscal on this, is that correct? Yes, I'm sure of that. Staff, is there a fiscal on this?
Not unless one's just come.
The motion is to report the substitute as amended. Clerk call the roll.
Senator Durant. Senator Aird. Senator Bagby. Senator Suederline. Senator Favola. Ayes 5, no 0.
And that will be the recommendation to the full committee. So when we get in front of the full committee, we should have the amendment that we discussed.
All right, thank you for your time. I really appreciate your help. Thank you.
Okay, let's move on. Senator Peake.
Good afternoon, Madam Chair and members of the committee. Yes, ma'am, 671, called the Youth Health Protection Act. And before we get going, I do have a couple of lines I would like to strike. So for an amendment, lines 64 through 69. So that's provision 3, and that's 64 through 69. And then lines 106 through 110, would like to strike those and move that amendment. The first part, the 64 through 69, talks about puberty blocking drugs and testosterone or estrogen. So I'm taking that out. So it's not prohibiting using any of those. And then lines 106 through 110 involve requiring a government agent or employee to notify the parents if they see symptoms of gender dysphoria. So we're taking that off of government officials, that they would have to notify anyone. So that's section C, 106 through 110, which then leaves the remainder of the bill, if, I guess, somebody needs to move those.
Second. All those in favor signify by saying aye.
Thank you, Madam Chair, then members of the committee. So that leaves the bill. The purpose of this bill is to prohibit individuals from having healthy body parts removed before they reach the age of 21. This is for individuals who are having gender dysphoria and may want to transfer from one sex to the other, which is not the one they were born. And it has all the exclusions for any kind of actual physical situations, emergency situations, or if they're born with both hormones or a mix or any of those things. It is meant to only apply to individuals 21 years or under from removing healthy body parts to transition from one sex to another or to have fake body parts instilled if that is their desire. And we've seen things in the news about this, some folks who transitioned at an earlier age, before the age of 21, sometimes before the age of 18, have had regrets. There have been numerous news stories about this that are nationwide, well known, and so this would just prohibit it. And it also coincided with a bill that we saw last year from Senator Edwards from Roanoke, who brought a bill to raise a lot of the punishment for juveniles from 18 to 21. And we heard a lot of testimony about what's called, we've heard some this year about juvenile brain, how juveniles, especially men, are still developing. They don't reach full maturity even up through the age of 21. And so you see a lot of this testimony in the law enforcement criminal aspect where they're saying, listen, this kid was 19 or 20, 21, he committed rape, he shot somebody, he killed somebody, but their brain had not fully developed, so they shouldn't be punished as an adult. And we've seen the same thing with people who have gender dysphoria, who have these body parts removed before the age of 21. So that's all it does, and trying to prohibit, because once those body parts are removed, it can't be undone. And so we don't let people under 21 buy tobacco, they can't buy beer, they can't buy a drink, but yet we will let them have healthy body parts removed. So I'm trying to bring in removal of healthy body parts in a line with drinking a beer, buying a mixed drink, buying tobacco products. That's the purpose of the bill.
Madam Chair, may I ask a question? Thank you, Madam Chair. So what lines remain in the bill now?
All 1 through 63, and then 70 through 105, and then 111 through...
Can you go slower real quick? So 64 through 70 are gone, Madam Chair?
64, yeah, so 64 through 69 are gone.
So 70 is starting number 4.
So 70 through 105 remain.
Names.
And then 111 through 150 remain.
Okay.
And that's the purpose of the bill. Any
Do you
questions?
have any, are there any speakers here who'd like to speak in favor of the bill? Please come forward. Is anybody who'd like to speak in opposition to the bill? Please come forward. Please keep your remarks to 2 minutes, and these are speakers in opposition. Go ahead, sir.
No, I'm speaking in support.
In support.
Yeah. Yes, and thank you, Madam Chairwoman, members of the subcommittee. And so I'm just now kind of digesting the changes to the bill. We have. I'll just speak to the surgery component of that, and let me just begin with a statement from the American College of Pediatricians. There is not a single long-term study to demonstrate the safety or efficacy of puberty blockers, cross-sex hormones, and surgeries for transgender-believing youth.
Sir, please identify yourself.
Oh, I'm sorry. I apologize. I thought I did that. Todd Gackey on behalf of the Family Foundation.
Thank you.
Puberty blockers may actually cause depression and other emotional disturbances related to suicide. In fact, the package insert for Lupron, the #1 prescribed puberty blocker in America, lists emotionally instability as a side effect and warns prescribers to monitor for development or worsening of psychiatric symptoms. Listen, every child deserves a natural childhood, one that allows them to experience puberty and other normal changes that shape who they will become. And a child who experiences gender dysphoria or identifies as the opposite sex deserves compassionate help, including counseling, professionals equipped with the ability to help the child navigate these difficult adolescent years. In fact, the best studies have shown that desistance is the norm for minors with trans identification, resolving on its own within, on an average of 85 to 90% of the time. So I can see the time wrapping up here, but our courts have long held that and recognized that states have a compelling interest to protect minors Sable versus Communications versus the FCC. There is a compelling interest in protecting the physical and psychological well-being of minors. Bellotti versus Baird. During the formative years of childhood and adolescence, minors often lack the experience, perspective, and judgment to recognize and avoid choices that could be detrimental to them. For these reasons and many others, we support the bill and the efforts to protect young minors from making decisions that will have long-lasting implications later in life.
I'll take the next speaker in favor. No more than 2 minutes, please. Those who wish to speak in opposition to the bill, 2 minutes each, but I would like to take no more than 7 speakers. Oh, okay. My colleagues are saying they have other places to be, but why don't we take the first 4 speakers who were lined up, 2 minutes each, and then the rest of you can indicate your support by just coming forward saying you support it. Okay? Come forward.
Hello, my name is Caitlin O'Brien. I am a transgender woman from Newport News, Virginia, and I had my own surgery 6.5 years ago in my 20s. There's a lot about what people can tell and a lot of hearsay about trends or fads, supposedly. I looked up my local organization when I was 14 in the Yellow Pages book for support. Not trying to get surgery, I didn't know who I could talk to. But it would have been really great to have had support. As far as having to go through puberty, there's some things that changes that I went through because of having had puberty that I can't reverse. If I could have just postponed that, a lot of things in my life would be easier. I've been living my life as a woman for many years. I have parental support now. I did not always. And nobody's getting surgeries under 18, let alone without parental support.
I understand.
Yeah.
We understand. Thank you.
I've been hearing a lot to the contrary. But,
Thank you. Thank you for sharing
Thank you.
that. Okay, the next 3 speakers, if you can keep it under 2 minutes, that would be good. I think we understand sort of the importance of this, but we appreciate you being here with us.
Hi, my name is Lumen. I'm a gender nonconforming person here to oppose this bill. Statistically, around 80% of transgender nonconforming people have considered suicide, and 40% have attempted suicide due to the lack of natural supports of families and access to gender-affirming care and mental health services. I'm a part of that 40%. I have met hundreds upon hundreds of trans people, and I have only met one person who has had regret of a gender-affirming surgery. And that person still considers himself transgender. You don't understand what it feels like to live in a body your entire life where you want to cut off parts of your bodies. I've had the honor to speak to elderly trans people, which isn't much in our community because of many people whose lives are taken or we take our own lives. I've met people who have had their genitals mutilated by themselves because they cannot stand the fact of having them on their body. To equate, I'm sorry, I'm shaking just to equate, yeah. Yeah. But I stand before you asking you to look me in the eye today and to not pass a bill that will result in the death of my community's youth members, or to look me in the eye today and to oppose the bill and to find compassion in your heart to oppose that bill.
Thank you.
because if not, then there will be blood on your hands.
Yes.
Hello. My name is Haley Salmon. I'm here with Virginia Student Power Network. I'm a transgender nonconforming person, and I'm demanding you oppose this bill. This bill is not here to do any good for the youth. It's here to erase trans kids and trans people. It doesn't look to take care of the youth's health. It looks to treat trans youth as a disease. And I'm going to keep it brief, but I just want to say that gender affirming care has saved lives. It saves lives. That has been a proven fact through research and personal accounts. And gender affirming care, in multiple studies has been shown to decrease people's negative mental health outcomes. So I believe this bill is not doing anything good for the youth of Virginia, and how it is positive for their health by any standard, I just couldn't understand. This does not show a care for youth and their health and safety. This shows a mass hatred for trans people.
I'm going to ask the rest of you to maybe just state your name and
I think you need to hear my story.
your opposition. Go.
Could I please tell my story?
Yes.
Okay, thank you. Thank you so much. Appreciate it. I'm Trey Eccles. I'm from Fairfax County, and I oppose this bill. I first tried to kill myself when I was in 8th grade because I had unsupporting parents. I had tried to tell them since I was 3 or 4 that I was a boy, and why were they confused? And then they wanted me to wear a bra, and then I swallowed a bottle of pills. So I thank God every day that my body is what it is today, and that things are gone, and that things are here. Every day I wake up and thank God for that. And the most insidious part about this bill, they said that counseling? No, it says no gender affirming counseling. Therapy is so important. And if you're not gonna let folks transition, then they need therapy. Because when I was receiving counseling in Indiana that my folks wanted me to receive, they told me if I would just shave my legs, my mom and I would get along. I then tried to kill myself again. In fact, I had 12 hospitalizations. They all stopped after I found Whitman Walker Clinic and an amazing therapist who, by the way, did not let me just transition. We spent well over a year in therapy. And when I got my phalloplasty, even though I'd been living as male for 16 years, it still took almost 2 years to get that surgery. Surgeries are not happening willy-nilly, and especially not with youth. But I beg you to not take gender-affirming mental health care away. Because I was on Medicaid, I was suicidal, I was not a functioning adult. I am now a software engineering manager. I contribute a lot of taxes to this state. I am a functional adult, and I would not be if I had not had the power to transition. Thank you for letting me.
Madam Chair, my name is Ranger Ballison. I'm with the Pride Liberation Project. I'm 18 years old. That's old enough to drive a car. That's old enough to work in this building as an intern, which I do. And that is old enough that if I wanted to, I could get married. I urge you to allow people like me, young people just like me, who look like me and who don't look like me, but all of them who have had similar experiences to me, to make decisions about our own health care. We deserve the opportunity to do that. Thank you so much.
Good evening. My name is Galina Varchena. I'm the Policy Director for Birth and Color, and on behalf of Birth and Color and the Virginia Reproductive Equity Alliance, we hope that you oppose this toxic piece of legislation.
Hi, I am Penny Page of the YWCA of Richmond, and also on behalf of Together We Will Henrico, expressing opposition to this bill.
Hello, Chloe Edwards, Policy Director with New Virginia Majority. I'm also speaking for Virginia Student Power Network today. Whether this legislation passes or not, I want the legislature to know that this harms trans students regardless. For those reasons, we continue to oppose bills like this.
Brianna Diaz, Policy and Ledge Counsel for ACLU of Virginia, and we oppose the bill. Thank you.
Afternoon, Narissa Rahman, Equality Virginia. The American Academy of Family Physicians, American Academy of Pediatrics, American College of Physicians, American College of Obstetricians and Gynecologists, American Osteopathics Association, and American Psychiatric Association, and the Medical Society of Virginia have all recently released statements in opposition to bills like these, and we oppose Senate Bill 671.
Thank you. Senator Peake?
Thank you, Madam Chair. I just want to briefly correct. This bill does not ban gender counseling and makes no mention of counseling, does not ban counseling, does not ban treatment, does not ban anything other than removal of healthy body parts.
Madam Chair.
And it provides for life-saving
Madam Chair.
surgeries. So that is it. And as far as 18 and under, they may need, 18 and under, they do need, might need parental consent, but from 18 to 21, they don't.
Madam Chair.
I think the discussion's now with the committee. Senator Aird.
Thank you, Madam Chair. I want to say, having heard adequate testimony on both sides, with appreciation to everyone who shared their personal story, I have a motion, and I would move that we PBI this legislation.
Second.
Okay, the motion is before us to PBI, and it's been seconded. Will the clerk please call the roll?
Senator Durant?
Nay.
Senator Aird?
Aye.
Senator Bagby?
Aye.
Senator Suderline?
No.
Senator Favola?
Aye.
Ayes 3, noes 2.
Thank you, Madam Chair, members of the committee.
Thank you. We will make that recommendation to the full committee. Senator Salim, you've got two bills before us, and would you like me to make the motion or to suggest to my colleagues that you want to roll 335 into 333? Is that correct?
Madam Chair, that is correct. And also there was another bill that was
Right. Well,
continued.
let's roll 335 into 333.
And then there's also a substitute.
And there's but I
after
have to
that
do
one.
the roll. I think I have to do the rolling first. This motion has been made by Senator Suline, seconded by Senator Bagby. Okay, so 335 is now rolled into 333. So let's focus on 333, which now has a substitute. Is that correct?
That is correct, Madam Chair.
Okay, I need a motion to adopt the substitute.
So moved.
And Senator Duran seconds that motion. All those in favor of adopting the substitute signify by saying aye. Aye. Okay, the substitute's before us. Go ahead.
Thank you,
Senator.
Madam Chair, and thank you to the committee. With a lot of discussion, when we rolled in with the new bill 333, would mandate both private insurance and state medical or Medicaid healthcare plans to cover persons who seek fertility preservation in cases of cancer where the cancer treatment is likely to negatively affect fertility. Cancer is something that is now treatable in some cases, and most folks can beat that. However, for certain cancers, the treatment has the unfortunate side effect of negatively impacting a person's fertility. At the same time, more people are delaying having kids until 30s and 40s. So what happens to young persons planning for children after receiving a cancer diagnosis? Often they need to scramble to preserve their fertility because the time between finding out a diagnosis and having to begin treatment can be quite short. In the United States, approximately 160,000 individuals between the ages of 20 to 45 are.
This is a substitute to 333, so this is the only bill before us. So we're all set.
I just want to make
Colleague
sure.
had a question. So the bill before us is really the bill that we're acting on, this substitute. Continue, Senator Salim.
Thank you. I'm just going to go on. Despite the fact that fertility preservation is an available technology, the costs associated with fertility preservation can put it out of reach for many, if not most of the costs already face, if not most of the folks that are already facing financial burden associated with cancer and cancer treatments. Neither Medicaid nor most private insurance cover fertility preservation, even when it's medically advisable. This means that a person who has cancer normally only has a very brief window of time to secure the funding necessary to preserve their fertility. Many people fail in this task. The idea that your personal access to wealth is what determines whether you can have a family is contrary to the principle of reproductive justice, fairness, and of compassion. This bill specifically, because when we combine it, covers individual with specific diagnosis, specifically cancer, to make it available that they can preserve their fertility. And I do have some folks that would like to speak on the bill and address any questions you may have.
I do have a couple of questions. I just want to be clear for the committee on the scope of this. So this would cover insurance plans. This is a mandate that insurance plans provide this coverage. I'm looking at lines 390 to 400. Council.
Yes, Madam Chair, that is correct.
So would it also include plans that have the capitated rate and they would be like your HMOs or other, not just straight insurance plans, but combination of insurance and provision of care, they would be included as well? Is it everything under 38.2? -34.9, because you've got a lot of chapters in here, so I'm thinking you're covering most plans that are approved by the SCC in Virginia.
Madam Chair, if I can refer you to lines 392 through 394 or 95 of the substitute, you can see that it extends to
HMOs.
Health maintenance it says each health maintenance organization providing a health care plan for health services shall provide coverage for, and so on, as well as each corporation providing individual or group accident and sickness subscription contracts.
Right.
Well
So it's just about everything the SCC would approve for market has an insurance coverage plan in the state. Is the state medical plan, medical assistance plan for our Medicaid recipients, that's covered in here as well as I read it?
Yes, yes, Madam Chair.
Okay.
That is covered starting on lines 256 of the substitute. That's where you see the amendment to the state plan.
Yep, got it. Okay, so this is pretty comprehensive in terms of who would be responsible for providing coverage.
Madam Chair, that is correct, and I do have someone that.
We could take your speakers unless you have something more you'd like to add. Okay, Senator Durant, there's a question.
Yes, thank you, Madam Chair. Does this, I guess is a question for the patron, does this change the fiscal impact that's been, I think, the most recent one attached?
Madam Chair, because when we looked at the two separate bills and then we looked at the fiscal impact, we spoke to DMAS and other parties involved. It does take away that fiscal impact because we removed the criminal portion that was already included in the prior bills. And I can also have counsel clarify if needed.
The criminal portion was removed, but the state plan would have to be amended to provide the coverage. So, as I read it, but I'll ask General Counsel. Is that your question, Senator Durant?
Yes, yes, Madam Chair.
Madam Chair, we cannot comment on whether or not there will now be a fiscal impact or change fiscal impact until since the substitute has just been offered. Now that it has been offered, and once the docket for full committee goes out and Senate Finance and Appropriations can look at it, we will have a better idea of what exactly the fiscal impact may be and whether it would have to be re-referred.
Usually we get the fiscal request when bills are before the parent committee. That's when the Finance Committee looks at the bills. It's when they're in front of the parent committee. So just for our information, I can't imagine that Senator Lucas would miss this. But for now, we're going to focus on the content and the speakers who might want to speak in favor of, you're speaking in favor of the bill? Yes. Okay, no more than 3 minutes total for those who are speaking in favor, in totality. Go ahead.
Yes, ma'am. Very, very briefly, one of the provisions, my apologies, Galina Varchana, Birth and Color Policy Director. One of the provisions that was added in the substitute is a requirement that DMAS ask the federal government essentially for matching funds. So theoretically, it would not go into effect unless federal money was available for this care. This is the same approach that has been taken by a few other states, including Utah, which has passed something similar very recently. One of the reasons that we're looking at this bill is, let's say you are experiencing cancer and you happen to be a Black woman. They might not even talk to you about fertility preservation because they're making internal assumptions about your ability to afford this kind of care. If you are poor, if you are on Medicaid, you won't even be counseled about fertility preservation when you are told that you have a cancer diagnosis that will require treatment that will cost you your fertility. We have kids who are experiencing cancer who are not being counseled appropriately because there are assumptions about costs. So we really need this kind of coverage to ensure that young people and people who are going through this have the time. We are limiting within the substitute to 1 year post-treatment, right, to hold the sperm and the eggs in preservation, to give people the time they need to make the financial arrangements and the decision that is right for them. Because right now, you might find out you have cancer on a Friday and you need to start your treatment on Monday in order to prevent death. So that's why we're asking for this coverage and why we're trying to move this issue forward. Thank you.
Sort of. Hello, I'm Heidi Dix with the Virginia Association of Health Plans. I just want to clarify some of the discussion. This did go to the Health Insurance Reform Commission, another previous bill that is very similar within the last 3 years, and it went through a step one process, which means that the Bureau of Insurance determined that this would require defrayal payments. So in addition to the state plan, for the qualified health plans under the exchange, you would need to make payments, defrayal payments from the Commonwealth to the plans. So this really, the private insurance part needs to go back to the HERC for step 2. Thanks.
We will have that conversation with the parent committee. HERC looks at insurance mandates. It's a committee that Commerce and Labor uses. But what I'm going to do is we're going to, however we decide to dispose of this, will be the recommendation to our parent committee, and at that point we'll decide if something has to be pulled out to go to HERC. Okay, colleagues, the discussion is with us.
Move the bill. Okay,
the amendment in the nature of a substitute has been moved that we recommend reporting this. Is there a second?
Second. Sure.
Okay. Will the clerk please call the roll? And we will have to have a larger conversation in front of education and health.
Speak briefly to that motion?
Absolutely. Senator Suderline.
Thank you, Madam Chair. I plan to vote for the motion, but I think that there's a good chance that we're going to end up having to take a different motion in full committee. So I just want to be very upfront with you and your advocates that based on the presentation, I think that this is a good thing to do, but I think that we need to go through the larger study. So I'm going to vote to report today. I just don't want you to be surprised if you see a different vote in committee because we have to route it somewhere.
We may have to take out parts of this. Senator Durant. Yeah. This one.
My apologies. Thank you, Madam Chair. Just also speaking to the bill, I want to echo my colleague, and there's just a lot to digest here, and I can't be subject matter experts on all of the minutiae of it, so take a look at it. But, looking forward to working with you and and maybe be able to answer some of the questions as we move forward in the parent committee. So thank you.
Okay.
Thank you.
Would you take the roll, please?
Senator Durant. Senator Aird. Senator Bagby. Senator Suderline.
Yes.
Senator Favola.
Aye.
Ayes 5, no 0.
Okay, well, we will have a positive report to the committee, but I think Senator Suderline gave you some wise counsel.
Thank you, Madam Chair, and thank you to the committee.
Thank you. Okay, is Senator, Senator Salim, you had one other bill. I think it had to do with the drug.
My apologies. I did have another bill, and I would ask the committee if we can continue that for 2025.
Second.
Okay, second. Well, let's just clarify the bill so the committee.
Help the senator.
This is Senate Bill 592. May I have
Yes.
a motion to carry it over? Second. All those in favor signify by saying aye. Aye.
Yes.
Okay, that was unanimous because at the consent of the patron. All right.
Thank you.
Thank you, Senator Salim. Okay, Senator Carol Foy, there are two bills that you have, and also, where is she? Is Senator Hashmi's here? Okay. Senator Hashmi, I'm glad you heard the conversation on Senator Salim's bill.
Oh, I wasn't paying attention. No, I'm
So
sorry.
now it's okay. At this hour, I understand.
I was just kidding.
Senate Bill 237.
Yes, thank you, Madam Chair and members of the committee. This is SB 237. The bill would codify the right to contraception in Virginia. And I'll just begin by painting a picture of the kind of crisis that we are facing, not just in Virginia, but around the country. After the fall of Roe v. Wade, we actually had one of our Supreme Court justices, Justice Clarence Thomas, who openly supported overturning the constitutional right to contraception. He made the suggestion that we ought to revisit Griswold, and this was back in June 2022. In addition to that, when the right to contraception was presented in the House of Representatives, 195 members of the House of Representatives voted against our right to contraception. And this puts so much in crisis, should that be ever overturned on a national level. You know, we took it for granted that Roe v. Wade would not be overturned, and yet we saw what has happened, the catastrophe and the unspooling all across the country of access to abortion care. And we simply cannot let the same happen to contraceptive care. Contraception, as we know, is essential not just for family planning purposes, but it is also so essential for so many individuals for maintaining and managing their health conditions. I have family members who suffer from extreme endometriosis, and without access to contraceptive care, they would face severe pain, severe crisis, would not be able to go to work on some days. It's unmanageable for many, many individuals that suffer from health issues that require the medication that's provided through contraceptive care. So when we codify the right to contraception here in Virginia, we would officially integrate the right to contraception into our state laws and we would provide a legal foundation for this right. It would prevent state interference on any individual's right to access contraception, and it would also be supported in their opportunity to fight against that any infringement on their right through civil legal channels. Madam Chair, that is the essence of the bill, and if you are taking testimony, I think we have some folks here who would like to speak to it as well. And I apologize, there was a substitute. I wrote a substitute big and bold on my on my sheet here.
All those in favor of the substitute signify by saying aye. Aye. Okay, the substitute's before us, but I believe the patron just explained the substitute.
It is the, yes, thank you.
I would take 5 minutes of testimony on either side of this, but it's in very good shape. So those of you who are in favor, you might as well just say love the bill, because I think the committee likes the bill, but come forward if you're in favor. I'm taking no more than 5 minutes of testimony, total.
Birth and Color and the Virginia Reproductive Equity Alliance like the bill.
Okay.
Thank you.
It's very good.
Madam Chair, Jamie Lockhart, Executive Director of Planned Parenthood Advocates of Virginia. We support the bill. Thank you.
Thank you.
Hi, good evening, Madam Chair, members of the committee, Latwyla Mathias, and we like the bill from Progress Virginia. Thank you.
Good.
Nicole Lauder at Williams Mellon on behalf of the American College of Obstetricians and Gynecologists, and we do support the bill. Thank you.
Thank you, Nicole.
Hi, I am Penny Page of the YWCA of Richmond, and on behalf also of Together We Will Henrico, support this bill.
Thank you.
Hi again, Brianna Diaz, Policy and Ledge Counsel for ACLU of Virginia, and we support the bill and thank the patron for bringing it. Thank you.
Thank you.
Chloe Edwards, New Virginia Majority. We support this bill and thank the patron for carrying it.
Great. Is there anybody in opposition to the bill?
Move the report.
Okay, a motion has been made to report the substitute. Will the clerk please call the roll?
Senator Durant. Senator Aird. Senator Bagby. Senator Suderline. Senator Favola.
Aye.
Ayes 3, noes 0, 2 abstentions.
We will make the like motion to our parent committee. Thank you,
Thank you.
Senator Hashmi.
Thank you.
Okay, Senator Bagby.
Good luck in the next committee. You all look better on this side. Good evening, Madam Chair, members of the committee.
Are we at Senate Bill 546?
Yes, Madam
Okay.
Chair. Madam Chair, this bill allows access of a family member or legal guardian to the individual undergoing an emergency custody order or a temporary detention order assessment during a mental health crisis in a hospital emergency department or healthcare facility, at which an individual is being evaluated so long as the person's presence does not create a safety risk or interfere with care. And I will move the substitute.
Okay, all those in favor signify by saying aye. Aye. Okay, the substitute's before us.
Thank you, Madam Chair. The bill acknowledges the important role of the family and legal guardians in informed decision-making and support during mental health emergencies, which improves both short and long-term mental health outcomes, and is a result of a number of individuals getting together that you may hear from today. And when I can come back, I will sort of wrap all that up. But there's a number of individuals that have worked hard on this piece of legislation. And without giving out too much of it, I will turn it back over to you, Madam Chair.
Thank you, Senator Bagby. If you have speakers here who would like to speak in favor of the bill, please come forward. I will allow 5 minutes in favor and 5 in opposition. And you're attempting to actually make the lives of law enforcement easier as I read the bill.
Yes.
Okay. Yes, sir. You may have the podium.
Okay. Good evening, Madam Chair, members of the subcommittee. My name is Liano Chiang. On March the 6th, 2023, my brother Ivor Otieno was smothered to death by sheriff employees and state employees, state hospital employees. 3 days earlier, police responded to a disturbance call from a neighbor who principally reported that my brother had been knocking loudly on her door. Police completely surrounded my brother.
Could somebody shut the door, please?
And my mother, terrifying my brother. After the prolonged encounter in the front yard, officers transported my brother via an ambulance to Parham Doctors Hospital, where my mother followed to make sure that she advocates for his mental health crisis. Medical staff noted Mr. Otieno was experiencing high anxiety, stress, and emotional pain, and was restless and distracted. Despite Ivor repeatedly asking to see his mother, my mother repeatedly asked to see him as well. Hospital security staff prevented my mother from seeing Ivor, stating that he would not be allowed visitors. I know two things. First, both officers and witnesses acknowledged my mother's calming presence on my brother, and second, that hospital providers reported that my brother was cooperative and engaging in treatment prior to my mother being impeded from seeing Ivor. In the past, this was never an issue. My mother would never be permitted to see her son, Ivor, seemingly by the unilateral insistence of hospital security officers, rather than the directive of any hospital providers or police supervisors, or superiors, excuse me. Despite medical providers' characterization of my brother's actions as evidence of being in a mental health crisis, hospital security officers instead labeled my brother's condition as criminal, which they used that incident to arrest him. My brother ended up facing 5 charges, even though he was in a psychiatric unit of a hospital exhibiting what many psychiatrists would deem symptoms of a mental illness breakdown. This conduct must stop, and you have the power to stop it today by passing Senate Bill 546. Thank you.
Well, Mom's coming next.
Your loss today.
Thank you.
This will make a difference.
Good evening, Madam Chair and members of the Senate Committee. My name is Caroline Ouko. I have served as a caregiver in the past. Ivor Otieno is my beloved son. On March 3rd, 2023, my son was experiencing a mental health crisis. Police officers obtained an emergency custody order, ECO, for Ivor and took him to Henrico Doctors Hospital, Parham. As I had always done in the past, I followed. When I got to the hospital, I asked to see Ivor, but I was not allowed. I asked several times. I literally pleaded to see my son, but was completely denied. And what hurts me the most is, even though Ivor was in a crisis, he knew who he needed the most, his mother. He was also asking for me. We were separated, and this separation prevented me from advocating for my son. If Senate Bill 546, if all of you, and I believe you can, work hard and pass this bill, this bill will not bring my son back. But I'm excited about what it will do for others. Ivor Otieno's law will give access to be with your loved one in the room during evaluation and stabilization. That access is so important for a patient in the midst of a crisis, and I'm speaking
Go ahead, finish your remarks. We'll turn the timer off.
Thank you. And I'm speaking from firsthand. My son needed me, his mother. And as a mother, there's no better person. You know your child. Ivor was a brilliant, empowered patient, but he needed me at this vulnerable time. I could have filled the void and alleviated his anxiety and frustrations. I believe if I was given access, he would have never been taken from the hospital and taken to jail, where he deteriorated. And in 3 days, my son was murdered. If Ivor Otieno's bill passes, it'll ensure that you have access and also empower doctors to make medical decisions without paying attention to outside noise from security officers. Ivor Otieno was about change. He was empathetic and inclusive, loving and caring. He cared and stood up for others. Those Ivor qualities makes this so meaningful and fitting that a bill in his name will serve and help save lives for generations to come. I'll close by quoting Reverend Martin Luther King, a great civil rights icon of our time. It was his belief that our lives begin to end the day we become silent about things that matter. Please adopt Ivor Otieno's law. I urge you to please make this happen. Thank you. Thank you.
Greetings, everyone. My name is Alan Chipman, and I support the bill. Personal friend of Ivor Otieno. Thank you.
Thank you very much.
Hello, my name is Lawrence West. I'm with Black Lives Matter Richmond, Virginia, and also Black Lives Matter Grassroots. I support this bill, and I would like to just state that you guys would be effectively decriminalizing mental health crisis.
Thank you.
Good evening, Madam Chair. Bruce Cruiser, Executive Director, Mental Health America, Virginia. We just want to lend our support to this bill, thank the patron, and thank the family for their courage.
Thank you.
Chloe Edwards, Policy Director, New Virginia Majority. We support this bill. We thank the patron for carrying it, and we thank you for those who have chosen to be vulnerable today to share their stories to create change. Thank you.
Thank you.
Madam Chair, members of the subcommittee, Josie Mace, DBHDS. We thank the patron for bringing the bill, and we support it.
Thank you.
Brian Kilmar for Decriminalized Developmental Disabilities, and unfortunately, autistics sometimes get TDO'd, and this applies. They need their parents with them to help them explain. We support this bill.
Peace and blessings, everybody. My name is Jafari Jones. I'm the president of BLM 757, also known as Black Lives Matter 757, and I support this bill. A mental health crisis should not be a death sentence in Virginia or anywhere else in the state or in the country. Thank you.
Thank you. Madam, I don't expect there's anybody in opposition to this bill. That's wonderful. It's a good bill, Senator Bagby. You're making a difference.
I think Ed had something first.
Not
and
if
then
you had closing remarks. Did you have further
No,
comment?
Madam Chair, I just wanted to say that this is a piece of legislation that, in all truthfulness, I was pleased because oftentimes we hear you all need to find something to work on together, Democrats and Republicans.
Yep.
And so when the governor's office called to say the family wanted to work on the legislation with me, it was meaningful. But when Mom came to my office to talk about her son, to talk about football, to talk about food, I heard my mom talking about me. And throughout this whole ordeal, all she wanted to do is bless the next family. She knows she can't bring her son back, but she knows there's a family right now going through crisis. And there's a family member going through crisis that needs to see a loved one, that needs a comforting voice. Each of us have a family member that we know if we step in the room, things will get better for them. And so this piece of legislation is going to help people help people. Thank you, Madam Chair.
You know, I think in the Commonwealth, we have struggled for quite some time with trying to put the right structure in place, the right policies in place to be supportive to those experiencing mental health crises or just our mental health system in general. And I want to express my deepest condolences to the family. And I feel that while this is the family representing the latest tragedy today, this has not been the only tragedy. And I think we have an obligation as a General Assembly to do something about that. And so I thank the patron for working with the family to bring this forward. And I, quite frankly, look forward to moving this legislation to the full committee so that we can continue it moving throughout the General Assembly.
We're going to make a difference with this legislation. So I will accept that as a motion
Yes.
to report the substitute bill. And Senator Durant, is that a second? A second. Okay, will the clerk please call the roll?
Senator Durant?
Aye.
Senator Aird?
Aye.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Favola?
Aye.
Ayes 5, no 0.
Thank you, family members. We're now going to report to the parent committee that this bill should go to the floor. And I never make predictions, but this time I'm confident that it's going to get it to the floor, and I hope it passes. So thank you very much for coming. Thank you, Senator Bagby.
Thank you. Thank you.
Okay, I see another patron here. Senator Carol Foy. And you've got two bills, Senate Bill 497 and Senate Bill 499.
Yes, Madam Chair. We can start with Senate Bill 497, Alternative Transportation Temporary Detention Orders. Oh, yes. Yes, Madam Chair. And before I begin, I would like to move the line amendment, and if the clerk can report.
Okay, so we're getting a substitute. Line amendment.
Would you like me to move the line amendment? Second.
Okay, all those in favor of adopting the line amendment signify by saying aye. 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 Okay, the line amendment's before us, Senate Bill 497 as amended.
Thank you, Madam Chair, members of the subcommittee. On March 3rd, 2023, Ervo Otinio, a 28-year-old Black man, was taken to a hospital during what his mother, Caroline, said was a mental health crisis. He was later arrested and taken to Henrico County Jail. 3 days later, on March 6th, he died while being admitted to Virginia's Central State Hospital, a state-run inpatient psychiatric facility located in Dinwiddie County. While in transport, officers allegedly used lights and sirens, even though there was no apparent emergency relating to his transport. In Virginia, those experiencing a mental health crisis are often transported to a mental health facility by law enforcement under a temporary detention order, otherwise known as a TDO. This method of transportation often results in further trauma, stigma, and can compromise treatment. This process also puts underappreciated stresses on law enforcement throughout the state, particularly those in rural areas. The time required to serve and transport individuals with temporary detention orders can consume many hours, taking law enforcement away from their primary community law enforcement duties. So there was a pilot program in 2015 in Southwest Virginia by the Virginia Department of Behavioral Health and Development Services that funded it, that allowed many adults experiencing mental health crisis to be diverted from law enforcement to a third party for transportation. And that's what this bill permits. Senate Bill 497 provides that when a magistrate is determining whether an alternative transportation provider is available for the purposes of designating a transportation provider for the transportation of a person who is subject of a temporary detention order, an alternative transportation provider shall be deemed available if the provider states that it is available to take custody of the person from law enforcement within 6 hours of issuance of the temporary detention order or an order changing the transportation provider. So what this does is open up the people who can transport a person to a mental health facility. So it's not only through law enforcement means. A person who is paranoid schizoaffective or having a psychotic break, they may be willing to go with someone they know or familiar with, instead of seeing the lights and sirens of law enforcement being taken into custody forcibly, which can only exacerbate the situation. So I think this...
Yes, I've been working on this area for a while too. I just want to note, though, that the healthcare provider would have to make a determination that the individual was not a danger or was not having a violent episode for a non-law enforcement or the designated alternative transport company. But there are many cases where a relative or a friend could take the individual, and that's what this opens up.
Madam
Yes,
Chair.
yes, Senator Aird.
So Senator Carroll, just to clarify, the alternative transportation provider, it could be a family member or someone that's not sort of a medical entity or a company of some sort. I just wanted to clarify.
Yes, Madam Chair, Senator Aird, typically you can have alternative providers. This really says that available opens it up to 6 hours.
Mm-hmm.
And so there's no misinterpretation that a person has to be immediately available to transport someone. As long as you could transport them within 6 hours, that's permissible.
But may I follow up? I think Senator Aird's question is she just wanted to clarify that it could be a family member or a friend who could be available within 6 hours.
That is correct.
Yes. Yeah, just be clear, because our past legislation opened it up to an alternative transportation provider who was actually on contract from the state. And we used the phrase alternative transport provider. And you're using that same phrase, but you have a different meaning. And that's why the questions are coming up.
Got it. Yes. And so my bill actually doesn't change any of the alternative transportation provider language. It pretty much changes what availability means, and that it's up to 6 hours.
And the fact that it could be a family member, which Senator Aird.
Madam Chair, if I could have council define, as we currently use, alternative transportation, or is there any such clarity that exists?
Madam Chair, I do not believe that there is a definition established in the code, although, Hannah, do you know if there's one in the regulatory code? No, okay. So Madam Chair, we do not believe that there is an established definition for alternative transportation provider in the code or the administrative code.
Thank you.
I guess the issue here is, though, that the one who's doing the evaluation of the person who's likely to be under a TDO would have to inform the magistrate that this alternative transportation provider could be available within
6 hours.
Yes, Madam Chair. So my bill doesn't address alternative transportation provider piece. It simply says that an alternative transportation provider is deemed available if they can transport the person within 6 hours of issuance.
Without a definition of what alternative transportation provider is.
Typically, but it usually is a law enforcement. However, if someone else is available, like a person's mother or spouse, and the person is not having a violent episode, then typically the magistrate can say that this person can transport this, the individual to a mental health facility.
Madam Chair,
Hannah, did you have a clarification?
Yes, Madam Chair. I just wanted to clarify that this is already in current code in the bill. If you look at line 25, it specifies whenever an alternative transportation provider is identified to the magistrate, which may be a person, facility, or agency, including a family member or friend of the person who is the subject of the temporary detention order, a representative of the Community Services Board, an employee of or a person providing services pursuant to a contract with the department or other transportation provider with personnel trained to provide transportation in a safe manner. That's already in existing law, so that's not changing.
That satisfied my inquiry. Thank you. No. That's all I was looking for.
Okay. It's just not used very often, which is probably the purpose of this bill.
So the bill just said this up to 6 hours.
Do you have any speakers that you want to bring forth, or we can certainly take a motion? DBHDS, you representative from DBHDS?
Good evening, Madam Chair, members of the subcommittee. Josie Mace, DBHDS. We thank the patron for bringing the bill, and we are in support of it. As you all know, improving the process and usage of alternative transportation has been a really big interest of the Behavioral Health Commission for quite some time, and it was a focus of a 2022 alternative custody work group that had a wide range of stakeholders participate. DBHDS has also been working to improve how often alternative transportation is used to make temporary detention easier on the individual and less of a burden on law enforcement. And we do have a subject matter expert here if you have any more technical questions.
Do we have any more technical questions, colleagues? I think we're clear on this. It seems like a very necessary step and a good step.
Hi, Chloe Edwards, Policy Director, New Virginia Majority. We're supportive of alternative transportation more generally. Access to it is inconsistent across the state. I've personally tried to use it myself or a family member and have been unable to get the support needed. So for those purposes, we think this continues to expand access and thank the patron for carrying it. Thank you.
Thank you. Colleagues, I think we're ready for a motion.
Move the legislation with the amendment.
Okay, is there a second? Okay. Clerk, please call the roll.
Senator Durant? Aye. Senator Aird?
Aye.
Senator Bagby?
Aye.
Senator Suderline?
Aye by proxy.
Senator Favola?
Aye.
Ayes 5, no 0.
Okay, we will report this bill to the parent committee as amended. Senator Carol Foy, Senate Bill 499.
Yes, thank you, Madam Chair, members of the subcommittee. Senate Bill 499, donor human milk banks, health insurance, coverage for donor human milk. Before I begin, I believe I have an amendment in the nature of a substitute.
Move the substitute.
Senator Bagby seconds that.
Second.
Okay. All those in favor of adopting the substitute signify by saying aye. Aye. Substitutes before us. Okay, Senator Carol Foy.
Would the clerk like to? Okay.
And I think do you have further amendments to this, or is this?
I think this is the final amendment. Yes, okay. It's a final amendment.
Just
yes.
Confirming. Okay. Mm-hmm. Go ahead. You may present.
Well, she wants to. Is it okay for the clerk to report on the
yes.
changes? Yes, thank you.
Of course.
Madam Chair, thank you. This substitute that you have in front of you essentially expands the existing, or the bill is introduced to establish a regulatory and licensure scheme for these donor human milk banks. So what it does is it directs the State Board of Health and the Commissioner to promulgate and implement and enforce certain regulations dealing with the licensure of donor human milk banks, renewal of licensure, disciplinary actions for violations of regulations pertaining to certain health and safety standards that, again, the department and the commissioner are directed to promulgate regulations for and enforce, provisions relating to disciplinary action and regulations for the suspension and revocation or denial of licensure. And it also makes it a Class 6 felony to operate a donor human milk bank that is not licensed as required by the article. And that is essentially what the substance.
Yes, thank you. Just to expound on that briefly, Madam Chair, members of the subcommittee, doctors and experts agree that a mother's breast milk is the best source of nutrition for a newborn baby. The American Academy of Pediatrics recommends breast milk be the sole source of food for all newborns up to 6 months. However, we know that that's not possible for many mothers, given the fact that there's adoptions, there are health issues that may make breastfeeding challenging, if not impossible. And that's where the human donor breast milk comes in. For me, my twins were born at 22 weeks. One of the reasons that they were able to survive is because they had access to donor breast milk, and they had access to the nutrients that were placed in the breast milk. And I can tell you that every time we go to visit Inova Fairfax, they are deemed to be miracle babies because the point of viability is 24 weeks. So I have firsthand knowledge on how important and necessary it is to have access to breast milk, especially for your micro preemies whose survival rate is very low. You also know that in Virginia, we're having a lot of difficulties with keeping mothers and infants alive, especially if they are Black and brown. In addressing the Black maternal mortality issue and Black infant mortality issue, I can tell you that this bill will go very far. A nationally represented sample found that human breast milk was associated with a 21% reduced risk of death for all infants and a 31% reduced risk for Black infants. A recent analysis linking birth and death certificates for all U.S. births in 2017 found that in any breastfeeding of Black infants is associated with a 17% reduction in infant mortality, 29% reduction in neonatal mortality, and a 13% reduction in post-neonatal mortality. For very low birth weight babies in neonatal intensive care units, the need for human milk is the highest, but Medicaid does not provide reimbursement. And that's what this bill mainly addresses. I would like to tell the committee that this bill has gone through HERC twice, and we are here today to ask for this bill to pass. I think the clerk did a wonderful job at summarizing what this bill does. I believe we have some semblance of as much peace in the valley that we could possibly get, especially from CHKD, which is the breast milk bank here in Virginia. And I can answer any questions that the committee may have.
Thank you, Senator. Do you have people who'd like to speak in favor of the bill? Please come forward. Please keep your remarks brief.
Sure. Good evening,
Welcome.
Madam Chair. Brian Thomas with Children's Hospital of the King's Daughters, CHKD. I'd like to thank the Senator for bringing this important piece of legislation back. We've been working on this for a couple of years now, and I think that we have reached some agreement on some of the many technical aspects, as you've heard some of the explanation of the bill, and wanted to offer our support for the legislation. CHKD, as mentioned before, operates the only not-for-profit milk bank in the Commonwealth. We also operate a 70-bed neonatal intensive care unit at our hospital where we provide this life-saving nutrition to some of our most fragile patients in that critical care unit. Our KD Milk Bank also provides this nutrition to specialty nurseries and other critical care units all across the Commonwealth and also up and down the East Coast. Often talking about helping our most vulnerable citizens, the kids, I think this legislation does do that. It helps those kids who are our most fragile patients in our critical care units, whose age is measured in days and weeks and not months and years, and whose weight is measured in grams, not ounces and pounds. So, as mentioned before, this has already been through the two-step assessment in HERC with a recommendation to provide the mandate coverage. So I would ask you all support this legislation. Thank you.
Hi, Chloe Edwards, Policy Director, New Virginia Majority. We support this bill. I'll also add that I'm a triplet myself. Me and my siblings were born 3 months early. We were under 3, I was the heaviest at 3 pounds, 12 ounces, and we stayed in the hospital for months before we could return home. My mom also almost died on the hospital table just due to a loss of blood. So as a triplet, everything comes in threes, but not necessarily breast milk supply. We're supportive of this bill. Thank you.
Madam Chair.
Senator Aird.
I just had a quick question of clarification, and I don't know if it's for council or if the senator wants to take it. Understanding just how sensitive what we're talking about is, I just wanted to know relative to the classic felony penalty, is there a system which requires it to be this, or why that was selected? And maybe that's council or...
Julia.
Madam Chair, thank you, and thank you, Senator. The Class 6 felony for licensure violations, such as in this case, does appear in other sections of the code. For example, 32.1-162.15 makes it a Class 6 felony to not be licensed and operate, establish, own, maintain, manage, or operate a home care organization. And there's a few other sections that impose that type of felony for operating certain facilities or organizations. So it's
consistent.
Thank you.
Yes.
Madam Chair.
Senator Duran.
Thank you, Madam Chair. Just a question on, I guess maybe the patron on, and I've got to go through and digest the new substitute. So I know you and I have talked about this one, so I'm going to go I promise to do my homework on it. But I guess I'm not too familiar with this realm of how it can operate, and I think I've seen on maybe social media before people are doing organic. Does this apply to people like that who are? I guess I mean, could it potentially be a barrier for those who are seeking to get that sort of access to support if their supplies dried up? And
I think the representative from CHKD will probably.
And I apologize
no,
if that's
no
already
worries.
been addressed on it.
No,
Just
it's
trying
a good
to.
question.
Sure, Madam Chair, Senator Durant, I think your question is can just families just access the donor milk, or?
I think.
Which
informal.
Informal.
Madam Chair, she's talking about informal sharing that is like conducted communally.
Sure.
Yes.
Yeah.
And I think about potentially barrier. I'm so sorry.
No,
Madam
go
Chair.
ahead.
Communities where there might be some economic barriers, and there could be some challenges in accessing through formal portals, and so I guess that's what I'm ruminating through my head is I don't want that, especially for women who might be facing some of those challenges and just kind of going through in that communal setting. Or would this apply to them if they've said I've got a surplus and I'm happy to continue and to share it?
Sure. So, Madam Chair, Senator Durant, I think the question is, can they provide or donate that excess milk that they have? So, at our milk bank specifically, we have certain criteria that we need to follow because of our accreditation currently with the Human Milk Banking Association of North America that allows moms and families that have the excess milk to come to our bank, get properly screened, have the milk properly tested to ensure its safety.
Sure.
And this would be the only milk that would be qualified per this legislation. You wouldn't be able to get any reimbursements for informally shared milk. You'd have to get it from a licensed milk bank.
This is the only way for moving forward in the Commonwealth?
No. This does not regulate informal sharing at all, and that's specifically mentioned in the legislation as well.
Again.
It doesn't affect moms personally storing their own milk or sharing it with other families. Right. I will say that the recommendation from the AAP, the FDA, and the CDC is to get milk from a licensed or accredited milk bank, just so that you know that all of that is safe. But this does not have any impact on informal sharing at all.
Right. Yeah. So you can choose to use this or not.
Sure. And for us, this is more used in a clinical setting. So this is for the kids that are very fragile or low birth weight in our neonatal intensive care unit, or they have a prescription.
Yeah. I'm thinking more on the scope of I don't want us to get into barriers for those who
No, this does not impact them at all.
No.
Senator Duran, if you want to give me your breast milk, you can totally give me your breast milk, and that'll be totally fine.
Okay, colleagues, I think this bill is before us.
Move to report the substitute.
Substitute with the line amendment. Okay.
Oh,
And there's a
amendment as a
second.
substitute. Amendment as a substitute.
Amendment in the nature of a substitute. That's correct.
Madam Chair,
Senator Durant.
I'm gonna go ahead. I want to support that because you and I have talked about this quite a bit, and I think in the scope, I think I'm gonna be okay with it, but just with some reservations because I haven't had a chance to take a look at it and a little more want to understand what the felony is that we're talking about with this one. So, but I want to see this move forward in committee so we can continue talking. So, thank you.
And if I may just briefly, Madam Chair and Senator Durant, when we found Peace in the Valley is something we had to include because it's consistent throughout the code. You can't just start pretending you're a hospital and providing services, giving people breast milk, things like that. So
I think I understand.
I am not a fan of felonies either. But again, to be consistent, that's what we did.
Thank you very
Well,
much, Madam Chair.
they are responsible for providing a certain quality of product.
And licenses,
And
yeah.
that's really what this is all about. Okay. A motion to report the substitute is before us. Will the clerk please call the roll?
Senator Durant,
Aye.
Senator Aird,
Aye.
Senator Bagby, Senator Suderline,
Aye by proxy.
Senator Favola.
Aye.
Ayes 5, no 0.
We will report our motion to the parent committee, which will meet at 8:30 on Thursday.
Thank you, Madam Chair. Thank you, members of the subcommittee.
Thank you. Okay, Senator Mulkey, are you here on Senate Bill 141?
Yes, ma'am, Madam Chairman. I have been tracked down. I have a bill I inherited from Senator Ruff, and evidently I didn't get a notification because I'm not Senator Ruff.
My apologies, I mispronounced your name. It's Mulkey?
Yes, that's okay. I go by anything.
Well,
I have a difficult
I need to
name.
learn. You're my colleague, so I want to pronounce your name properly. Colleagues, it's Senate Bill 141.
So this is a sweet little bake sale bill that has nothing to do with a felony. This came to my attention, as I said, I inherited it. I did not know it was up today, so I don't have anybody here that's an expert on it, I don't believe. But it came about because people were being allowed to, the Virginia Department of Health was allowing bake sales at farmers markets. Like if you were baking these goods, let's say the fire department was having a bake sale, they were allowed to have that at the farmer's market. But if there was a festival in town, these were like 501c3 organizations. If there was a festival in town, they were not allowed to have their same baked goods down the street at the festival. They weren't allowed to go outside the farmer's market. So this was, I'm going to read what they told me. On one hand, a bake sale for an organization can take place at a farmer's market. However, that same baked good baked in the same home-based kitchen is not allowed to be taken to a festival or event such as our holiday bazaar. These events allow the organization to reach a wider audience. The baked goods come from the same kitchen, therefore should be able to be sold for off-site consumption at both locations. It just gives these organizations a wider availability of places to raise money instead of just being at the farmer's market.
May I say it another way?
Sure.
So it gives these certain nonprofits, as you've defined it, an opportunity to sort of have an event without getting a permit where food is prepared. If
Yes.
food is prepared at their home, or so they don't have to get a permit. Is that a fair presentation?
It is, and it says that they have to be labeled and specify that they've been made in an uninspected home kitchen as well.
As well.
Yes.
I think there would be a lot of groups that would certainly benefit from this, and the irony is it's probably going on now and we don't know it.
Yes, but I think that some people got caught in my district.
Interesting. So sometimes there's a story behind our bills, right?
Yes.
Often. Do you have any speakers that you want to speak? That you said you hadn't lined anybody up? Okay, I think
I almost had gone home. I didn't know I had a bill up today.
I think it's a pretty straightforward bill. Colleagues, did you have any preferences here, or?
Move to report.
Okay.
Madam Chair.
Yes, and there's no amendment, no line items. It's the bill is introduced. I think it's the first one we've had today where it's the bill is introduced. A motion was made to report. Senator Suderline.
Just before, I think I walked in at the very beginning of this, but did someone from the agency speak about this? They left already?
Everybody loves it, Madam Chairman. Senator Suderline, everybody loves it. Everybody loves a bake sale.
I think there might be someone standing up. I don't know if they love it or not, but let's hear what they have to say.
Please come forward.
Hi, Julie Henderson. I'm with the Virginia Department of Health.
And do you support the bill?
We don't have a position on the bill currently. Is there a question that you have about the bill specifically? Or?
Well,
Madam Chair?
Suderline.
Yeah, I think I might. So was it the Department of Health that enforced the current law?
Yes.
And so they were enforcing the current law, I guess, to the displeasure of some of then Senator Ruff's constituents. Should we continue that policy or not continue that policy is my question.
Are you asking about current policy?
Well, it sounds like Madam Chair, we'd be changing the current policy, so I guess they wouldn't be able to enforce it. I guess resources were being expended, enforcing this. And so I'm curious what the thought is if we should continue down this path or not.
I guess you're asking for a policy determination, or are you asking for technical?
Right.
You're asking for policy determination. Does the representative from the Department of Health feel comfortable offering a comment?
To allow a policy instead of amending the law? Is that the question?
Well, I think that's where he's going.
Okay. So currently, I can explain how we currently enforce. So currently, in the law, if someone is, you explained it well, I think, operating from a fire department, a church, they can serve food without a permit and without inspection at an event that they sponsor or hold. If they go outside of that to either another church, another fire department, or even a farmer's market or any type of event, say it's Browns Island, event being held there, they cannot do that without the benefit of a permit and inspection. So this bill would say that those entities can now go to any event within the state without the benefit of a permit or inspection.
But labeling food stating that it was prepared.
I didn't see that in the language of the bill, so I don't know if there's an amendment.
I think Senator Mulcahy, did you mentioned that in your presentation that it says here 1 or 2 days at which food prepared in the homes of members, prepared in the kitchen of the church, is offered for sale to the public.
I didn't see anything about labeling in the bill.
But I thought there was a mention that a label was.
That's go ahead. That's Department of Agriculture. The Department of Agriculture law requires labeling for cottage foods. We're not talking about cottage foods here.
Yeah, we're talking about home foods. Yeah, I don't either. I was just catching the comment that was made. Senator Suderline.
So I'm just trying to get my arms around this. I don't know if we're really just getting rid of permits altogether. Because it only adds or participate in. And then the other change is they want fundraisers to be one word rather than two. So I'm trying to figure out what exactly, how significant this change is. And then, if this is necessary because the agencies were enforcing something that the senator didn't like what was happening to his constituents, if that, what I'm trying to figure out what we're actually changing.
Go ahead.
I can only,
Senator Malkai.
Madam Chairman, Senator Sudeline, I can only say that the Chamber of Commerce executive director that came and tried to explain this to me said that they were wanting to be able to go to festivals, that these people were wanting to go to festivals and participate in fundraisers that they could do at their facility now and sell the same foods, but be able to go outside of, like, say, the fire department or the farmer's market. It's the same food. They just want to be able to go down the street when there's a street festival or a, let's say, Harvest Festival and sell the same food without getting a permit. It's the exact same food, exact same street. It's just participate in the festival.
No, my understanding is, and I'll ask General Counsel to confirm this, rather than just keeping the homemade food within the family, within their own church bazaar, within their own church fundraiser, this would allow them to take homemade food to a broader venue for a one-time event. They'd have to participate. Is that correct? Did I explain it correctly? Okay, Senator Bagby.
I think I fully understand what it does. What's the limit on it?
In terms of food?
Yeah, I mean, because if I was Nabisco, I would say, hey, I'm a 501c3 and I'm going to sell X amount of cupcakes
At 3 events.
At all events.
Madam Chairman, but is Nabisco really a 501c3? You have to qualify to be one.
Right. No. But what I'm saying is,
Senator Bagby.
Yeah. What I'm saying is, anybody could associate themselves with a 501. We run into that all the time with with folks associating themselves with 501c3s in gaming and a number of other things. So it has to be some parameters and limits on how much they're selling per year. The labels is what I thought I heard you say, which was I was perfectly fine with the labels, but it has to be some kind of label or signage, and it has to be a limit.
Senator Malkai, in other words, you're saying a 501c3 can only go to 3 events a year. You're not saying it, but that's a guardrail you would, or whatever guardrail you think, but it should be sort of a limited number of events per year.
Or Madam Chair.
Senator Bagby.
Or $5,000 worth of goods. Something that.
Senator Malkai, would you be willing to entertain an amendment? I think it's more complicated getting to the $5,000 worth. I don't know how you put a value on spaghetti and meatball dinner, but you could put a value on the number of events an organization could go to without a permit, maybe annually, if that is your. I can add. I think General Counsel is drawing up something now.
Madam Chair.
Would you, Senator Malkai, accept this as a friendly amendment? Where we're heading? Yes, Senator Durant.
Is this our last? Can we pass this by for the day, or is ours our last?
We're getting late. We have to get things out this week because next week we're going to be crossing bills over. So if you're going to have a bill, we need to fix it now, today, because we have to report to our parent committee on Thursday. Hannah? Or Julia, one of you, do you have something that may address Senator Bagby's concern?
Yeah. Madam Chair, thank you. So we may have to look a little bit into any sort of existing caps that there may be on things such as this, because the only new language, as the subcommittee members identified, is the or participate in, and this exemption is exempting these enumerated entities from the provisions that are applicable to restaurants, There may be additional provisions elsewhere that can supply sort of model for a certain monetary or like monetary cap per year for sales or a certain number of events. But we can definitely make an amendment to that effect if just after we look into a little bit what existing standards may
Okay, a
be.
suggestion was made that the patron agree in concept to some type of limit on the number of events annually. And staff can draw up the amendment, and it can be offered to the Ed and Health Committee on Thursday. But we really, if you agree, I'm going to move that amendment in concept.
I agree.
Okay, so
Madam Chair, I make the motion that in concept, the amendments for the number of events and labeling, I make the motion to report.
Okay, and is there a second? Okay, all those in favor signify by saying aye. Aye. Okay, so with that, we could have now a motion to report the bill as amended.
Motion to report as amended, Madam Chair.
Second.
Okay, okay, will the clerk call the roll, please?
Senator Durant,
Aye.
Senator Aird,
Aye.
Senator Bagby, Senator Suderline,
Abstain.
Senator Favola.
Aye.
Ayes 4, no 0, one abstention.
Okay,
No cupcakes for you, buddy.
That's right.
you're going to chair. I'm the last on the agenda. I have 2 bills, and this will complete our agenda for this afternoon. Chairman Back?
There we go.
Okay, Senate Bill 176. This bill is a recommendation from the Behavioral Health Commission, and it also came out of a JLARC study. And I would ask, there's an amendment in the nature of a substitute. It's dated January 18th, so I would ask that the committee adopt that.
From Ed, second from Durant. All those in favor express by saying aye.
Aye.
Those opposed?
Okay, Mr. Chairman, what the bill does is it directs the Secretary of Health and Human Services to convene a work group with the stakeholders, the relevant stakeholders, including local community services boards, the Virginia Health and Hospital Association, and others, to come up with a plan for transitioning patients who come to our state mental health facilities that really have neurodevelopmental or dementia issues. They do not have other issues that our state health facilities would normally address. Our state health facilities are not equipped to address the neurocognitive or neurodevelopmental or dementia. And now there are mental health conditions that our facilities can address, but it's not a good practice to mix both populations. But this work group has to come up with a way for ensuring that our private sector can then provide services to the population that we believe would be better served outside of our facilities. And at the provisions of the Act, I lay out how we're going to deal with the temporary detention order process, but the plan has to come back to the General Assembly in 2025 to get reenacted. So what you're voting on is a task force, their charge, and the fact that what they come up with will have to come back to us in 2025 and have to be reenacted.
Thank you. Any questions from the committee? Those who are here to speak in favor?
Administration.
Mr. Chairman, Josh Myers with the Alzheimer's Association. With the substitute and the delayed enactment, we're very comfortable with this now and thank the patron for moving this forward.
Opposition? Is there a motion?
Move to report.
Is there a second? There's a motion and a second.
To report the substitute.
To report the substitute. Clerk.
Senator Durant. Senator Aird. Senator Bagby.
Aye.
Senator Suderline. Yes. Senator Favola.
Aye.
Ayes 5, no 0.
Mr. Chairman?
Senate Bill 178.
Yes, sir. So this is a Section 1 bill. It's very short. It merely directs the Office of the Inspector General to develop a plan to fulfill its obligation to investigate complaints of alleged abuse and neglect or inadequate care at a state psychiatric hospital, and to submit its plan for investigating such abuse to the chair of the House Committee on Health, Welfare, and Institutions and the Senate Committee on Education and Health, and then to submit an annual report thereafter.
Thank you. Anyone here to speak in opposition? Is there a motion? There's a motion. Is there a second? Although, yes. And the clerk?
Senator Durant. Senator Aird.
Aye.
Senator Bagby.
Aye.
Senator Suderline. Yes. Senator Favola.
Aye.
Ayes 5, no 0.
Thank you, Mr. Chair. At this point, I'm going to ask the clerk, does that conclude our agenda for today? Okay, so I'll entertain a motion to adjourn.